people of the state of Michigan versus Skeeter Willie. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Barb Luxon on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Skeeter, standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Excuse me?
Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And have you had enough time to speak with your attorney?
Yes.
All right. Sir, you pled guilty to count 2, larceny in a building, punishable by 4 years. And I now have, and you're placed on probation, and I now have a bench warrant that alleges as follows. On or about April 5th, 2026, you assaulted Samantha Connell, Connell. Count 2, on or about April 5th, 2026, you had contact with Samantha Connell in violation of a personal protection order. Is that the extent of the violations?
Yes, Your Honor.
All right, and we have Michaela Kirchen here on behalf of probation. Are there new charges?
Yes, Your Honor.
There are, Your Honor. They are not in our county. They are in Eaton County. It looks as if those charges are, as far as I'm aware, domestic violence, third offense, and there is a PCC set on Monday, the 27th. Unfortunately, I do not know the status of the PPO at this time.
All right, and but that's all out of Eaton County?
Yes.
All right, so counsel, you're waiting further arraignment?
Yes, Your Honor.
Well, there's nothing we can do with this until after that case. There's nothing we can do with this till
Right.
after that.
Correct.
But let me just ask this, when did you plead? You pled December 2024, what has he done on probation?
He has not had any programming that was ordered. He was just ordered to pay restitution. At this time, he's paid $350, but he still owes $9,959.
I didn't order anything but restitution?
Correct, Your Honor.
Are we sure?
When I was reviewing his orders, that's all I came across. He's just been working and paying on his restitution.
So how much does he pay?
$350.
In 2 years?
Yes.
I have to go back and see what else I ordered. I'm sure he's not supposed to violate the laws, use alcohol, drugs, he's supposed to pay the restitution. I don't know. I have to go look and see. But sir, are you working?
No.
When was the last time you held a job?
The day I got picked up.
On this?
Yes.
So you have been working. What is your employment?
I lost my job.
What was it?
Fiber optics or T-fiber.
Fiber optics? So you're making good money? So you have extra money in your pocket every month that exceeds your bills? So yes or no?
No, I don't have extra money in my pocket. I make sure that I pay on my restitution. I just started the T5. I was training for about 3 months on that.
Okay, so how much do you make?
I didn't even get it was my first day of with jobs getting sent to me. It was literally my first day.
All right, well, here's what we're doing. And if anybody doesn't like it, I guess you can appeal, but it's in front of me. I'm gonna have to set this, but meanwhile, because the amendment should be, has failed to pay restitution regularly, hasn't held down a job, because I'm sure he was supposed to hold down a job. We go back and look at my record, but I'm sure I told him to keep a job at a minimum So you can pay this, have a wage assignment, anytime someone's not paying on my docket, I always ask that a wage assignment be in place. So there's gonna be work seek program, wage assignment, and we're extending this. So what did I give him? I originally gave him,
Give him 24 months, Your Honor.
well, great, now he's got 5 years.
Judge, I do want to add something. Mr. Skeeter tells me he has been paying $20 a month. He's telling me that I think whoever was his agent told him that's all that he had to pay.
Probably because he was underemployed. He's gonna get employment. He's got fiber optic skills. That's a good paying job. We're gonna get him a job in that. There's gonna be a wage assignment and probation is extended to 5 years. And in case, for whatever reason, these requirements were not written, let me go over what your requirements are. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have money for those things, you have money to pay your restitution. You will report truthfully monthly to probation or as often as they want to see you. You will regularly provide proof of employment. You will take a cognitive behavioral program so you learn to make better choices. If at any time you are unemployed, you'll be part of a work seek program. If you need additional training, you will participate in that. You will have no less than 3 applications for employment per week with proof of that. You'll not engage in any assaultive, abusive, threatening, or intimidating behavior. You'll obey all court orders, recommendations from all treatment providers, including probation. You will not have written, verbal, electronic, or physical contact with anyone housed in the Michigan Department of Corrections or who's on probation or parole without permission of probation. You will not use any object as a weapon, no guns, no ammunition, no imitation of a weapon. You'll not be in the presence of anyone who has any contraband. You'll allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer. If there's reasonable cause to believe you have items that do not violate the conditions of your probation, you must report any arrest or police contact, personal protection order placed on you, loss of employment or change of residence to probation within 24 hours. Weekends and holidays are accepted. So if something happens on Friday, tell us on Monday. If Monday's a holiday, you tell us on Tuesday. Apparently, there is a personal protection order in Eaton County, so we know about that one. If there's any others, we'll need to know about those within 24 hours. You'll comply with all conditions of all courts, including the personal protection order requirements, whatever the judge set out in there. You will serve 365 days jail with credit for how many days does he have so far? He had 2 before, now how many does he have?
8 days with the current violation.
That includes these 2?
No,
So
10
it'll
total.
be 10 days, the balance is held. Any additional days he gets on this will count when he's in front of me. Again, I imagine they're gonna transport him back to Eaton County, right?
I believe so, but he was out on appeal bond, is that correct? He may get released after for recording twice.
Well, I'm not releasing.
Okay.
You'll pay the restitution. And that is joint and several with Mark Bull and Aaron Brewer, I think. The total at some point was $30,309. I don't know what it is, but I do have notes. I have different numbers for notes, and maybe you can explain that to me, sir, because I have something that you received $3,000 times 40%. That's $4,200. I don't know what that is.
Your Honor, I'm looking at the PSI right now, and I'm seeing marked by the previous prosecutors that the restitution was to turn over the remaining copper in the defendant and co-defendant's possession within 30 days. And the restitution I have is a total of $10,309 minus whatever that remaining copper would have added up to.
Okay, so that's why I have different numbers, it's, so originally I had 30,000, so now it's based on that, because that, I do have that number written down as well, I have a bunch of numbers, $10,309. And then I'm unclear about the rest, less the value of the copper turned over. Sir, do you know about that?
Yes.
What's the story there?
You came up with the number 30,000 and he was on the screen. He said something that just didn't, it didn't sound right. So you told him, you're not going for that.
So we did the 10,309 instead.
And
what?
then said, yeah, and then I said, you said instead of giving him the money, just turn the copper in and give it to my attorney, and the attorney will give it to you, and then they will be taken off of the.
Did he turn the copper over?
Yes. No, I'm sorry, not the receipt or the check for the copy, not the copy.
Okay, so was that check turned over?
Yes.
What was the amount of that check? I have something that says 3,000. Let me see the probation. Restitution in the amount of $10,309 payable to Mark Bull, jointly and severally with co-defendant. Execute a wage assignment. I do remember some conversation about that, and I've got some notes, I just don't know, we have to go back and look at that, so council, maybe you wanna do that. And see what check was turned over, or what item was turned over, and if there's a credit. Because he's not gonna be released from probation until, and I made it clear in this, he's not released until the payment is made. So, you wanna get off this, start paying and figure out whatever it was that was turned over.
I think we're in the process of trying to figure that out now, Judge. I think another attorney, Martin Foley or Foley, I maybe pronounce his name wrong, handled the case. I know there was a co-defendant. I wonder if that was conflicted out because we represented the co-defendant.
And I will say that the co-defendant, it appears that the case was ultimately dismissed against the co-defendant. So it looks like it's just Mr. Kittle that has pled.
Well, did the co-defendant was it dismissed because he made payment? I wonder about
No,
that.
it was dismissed at the preliminary examination due to issues with the testimony.
Okay, well, I don't know, maybe we can go back and check the transcript, but also, sir, if you turned over something, we need to backtrack that, so you've got some homework to do. So we can amend whatever amount is owed. If you would like me to release him on a PR bond, I want the Eaton County matters, I wanna see what they're gonna do.
You want the what?
I want the Eaton County matters handled, I wanna see what they're gonna do.
Once I know what's going on, I can bring in most of the court's attention.
I'm here. Thank you. I guess let me just say for the record, I don't mind if we transfer him to Eaton County, I just don't wanna release him, so.
Right.
Whatever it takes to effectuate that, so if I need to give him a PR bond in order to effectuate the release to Eaton County, that's fine, but meanwhile, I'll await whatever instruction there is, we need to get him to Eaton County, get that cleaned up, and then back to me to see where we're at.
I get you.
Your Honor, do we want to set a control date then?
Yes. Well, I don't know how long it's gonna be, I'm gonna give you a date, but then council, move it forward or backward, how's that? Because I don't know how long it's gonna take Eaton County to deal with this.
Could be quick, it could be short, I don't know, Judge.
Right, so when's the preliminary exam?
The preliminary examination, based off of the PCC date, Your Honor, I believe would be not next week, but the week after. So sometime on the week of May 4th to May 8th.
All right, so why don't we bring him back May 13th? And let's just say 11 o'clock, and then we'll change that as we figure out what's going on.
Is that a Wednesday or?
To Wednesday.
Right.
That's just a control date. We can make it earlier or later, depending what they do.
I think
You
that's
can always
perfect.
petition me for PR or whatever, but I want to get these issues resolved.
We call this a status conference.
No, we're gonna call this a, bond violation / probation review.
PV.
Cause I'll be able to get some information, I'll talk to whoever, I know he can kind of see what I can find out. I think I know that.
Okay, thank you. I'm just knowing that he's arraigned on this, and then we'll see what we do. Like I said, if you need to move this, we can do that. Anything else for the record?
No, no, no.
Nothing. That's all.
Pretty Jason Quinn next. Either or is fine. Okay, I apologize, we're doing Puckett next.
Fine, yeah, for sure.
Yeah, the orders in here.
And I kind of, I can do.
I'm not, something's not adding up. What, to revise the rights, if it's two different files?
Yes, I think we have to file on each. You can ask the clerk. I think we need to, it's right here.
The other one would be a misdemeanor.
Still need device of rights. That doesn't change.
That's true.
That's always the one.
This one we might.
Okay.
Just hang on.
Okay.
How many Brady violations or spoliation issues?
Check it. So,
We may approach the documents.
This is docket 256224 FH, people of the state of Michigan versus Justin Michael Puckett, and 261702 FH, people of the state of Michigan versus Justin Michael Puckett. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Barbox on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson, on behalf of Justin Puckett, standing to my right today, Your Honor.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Yes, ma'am.
Is it anything that would interfere in your ability to understand your attorney or the court? Is there medication you're supposed to be on that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And have you had enough time to speak with your attorney?
Yes.
All right, now, on behalf of the people, I have a felony complaint and don't have a felony information. Has it changed?
In regards to which file, Your Honor? The
Oh, I'm
26
sorry,
file?
on the 25 file.
Oh, I can give you a copy of the information, Your Honor.
Okay, and I do have a felony information on the 26 file. Thank you. Sir, I understand there's going to be a plea today, is that correct? And are you a US citizen?
Yes, ma'am.
Graduated from high school?
Yes, ma'am.
Are you generally, when you're not in lockup, gainfully employed?
Yes, ma'am.
What do you do?
I worked at Martin in Jonesville.
A what?
Martin in Jonesville.
Martin?
Martin RTINREA.
Oh, Martin, what is that?
It's a factory,
Factory?
warehouse
Okay.
distribution,
Oh, okay,
parts making welding, things like that.
okay, good. All right, with what you're pleading to, which we'll talk about in a moment, were you on probation, parole, or bond conditions before another judge?
Not that I'm aware of.
Okay,
I don't believe so, Your Honor.
thank you, counsel. On behalf of the people, what is the plea agreement?
Yes, Your Honor, there'll be a global resolution in this file, in these matters. In file number 25-6224 FH, the defendant be pleading to count 1, criminal sexual conduct in the 3rd degree, and count 2, stalking domestic relationship. Upon successful plea and sentence, count 3, criminal sexual conduct in the 3rd degree, as well as the habitual offender 2nd status will be dismissed. There will also be a fixed minimum of 36 months at MDOC in regards to that file, Your Honor. In 26-1702 FH, the defendant be pleading to an added count 2 of use of methamphetamine. Upon successful plea and sentencing, count 1 will be dismissed, as well as the habitual offender status.
Is that also habitual too?
That's also habitual to, Your Honor, correct.
Thank you. Full, fair, accurate, and complete?
Yes, Your Honor.
Sir, full, fair, accurate, and complete?
Yes, ma'am.
Counsel, you're waiving reading the habitual second of both files? as
Yes,
well
Your
as
Honor.
Count 3 and the 25 file and count 1 and the 26 file?
Yes, Your Honor.
Thank you. Counsel, as to the remaining counts.
Thank you, Your Honor. In 25-6224 FH, people of the state of Michigan versus Justin Michael Puckett, state of Michigan, county of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, criminal sexual conduct 3rd degree, force or coercion, on or about December 25th, 2024, at 1997 Lake Lansing, number 1, Haslett, Michigan, 48840, Ingham County, state of Michigan, the defendant did engage in sexual penetration, to wit, penis and vagina, with April Maria Garcia, using force or coercion to accomplish the sexual penetration, contrary to statute. SOAR notice. This is a Tier 3 offense under the Sex Offender Registration Act. HIV/STD testing notice. Take notice that pursuant to MCL 333.5129, upon bind over to circuit court or recorder's court, the district court judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV, if the judge determines there is reason to believe the violation involves sexual penetration or exposure to a body fluid of the defendant. If the district court determines that the testing is not required, upon conviction, the court must order the defendant to be tested. This is a felony that is punished by up to a maximum of 15 years, mandatory AIDS/STD testing, and DNA to be taken upon arrest. Count 2, stalking domestic relationship. On or about December 26, 2024, through and including January 3rd, 2025, at 1997 Lake Lansing, number 1, Haslett, Michigan, 48840, Ingham County, State of Michigan, the defendant did engage in a willful course of conduct involving repeated or continuing harassment of April Maria Garcia, an individual with whom he/she had a dating relationship, the conduct being such that would cause a reasonable person to feel terrorized, frightened, intimidated, harassed, and molested. And such conduct did cause April Maria Garcia to feel terrorized, frightened, intimidated, harassed, or molested, contrary to statute. This is a misdemeanor that is punished by up to 1 year and or $1,000 and up to 5 years of probation. File number 26-1702-FH, People of the State of Michigan versus Justin Michael Puckett. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and on the location described below, the defendant in an added count 2, controlled substance use methamphetamine, on or about October 8th, 2025, at Saginaw Highway / Grand River Avenue, East Lansing, State of Michigan, 48823, Ingham County, State of Michigan, the defendant did use the controlled substance methamphetamine, contrary to statute. HIV/hepatitis testing notice. Take notice that pursuant to MCL 333.5129, upon conviction, the court must order the DNA to be tested for hepatitis B infection and for the presence of HIV or an antibody to HIV if the crime involved intravenous use of a controlled substance. This is a misdemeanor that's punished by up to a maximum of 1 year and or $2,000 and mandatory AIDS/hepatitis testing and intravenous use, and against the peace and dignity of the state of Michigan.
Thank you. Before I turn to defendant, counsel, I have a couple of questions. One is, I only saw the habitual on 1 and the 25 file, not the 26 file, so.
So the habitual would have been submitted in a, we've changed our office's policy in regards to doing habituals. There should be a separate notice in regards to habitual offender status that should have come up with the bind over packet with the information.
Okay, I don't see that, so.
I do have a copy of it, Your Honor, and I'll give that to you.
It's gonna be dismissed, I'm not concerned about it, I was concerned it was not on this, and I was not informed that your office changed that, so we need to start, I guess, looking for that or making sure that we have that. Next issue is, I read this habitual, which probably would read the same on both. It doesn't appear on the habitual that he has a prior drug offense. Is he eligible for 7411 on this? And if so, also the agreement should be that the sentences run
Concurrent, and I would agree with that, Your Honor. Let me look.
So I'm going to add that on because where it says fixed minimum, it should be also added sentence runs concurrent.
The
Any
people would have no
objection to
issue
being
with that, Your
correct in
Honor.
that?
Correct, Your Honor. And I think Judge, let me check with you. Mr. Puckett does not have a prior drug.
He does not, Your Honor.
Well, I think he's got enough problems, so I'm gonna grant 7411 on this file, not clearing the courtroom because it's useless at this point, but I think this should become a non-public record if he behaves well on while he's incarcerated. Well, sir, at least to the map, because you don't have a drug history here that I see. I'm gonna give you a non-public record, you just behave well so it doesn't get removed, okay? All right, so then you just got much bigger issues on the other files, so clearly you need some help. I'm not gonna make it worse for you. I think it's important that you focus on this bigger file and we'll give you the 7411, but it's yours to lose. I can take it away as quickly as I give it to you. Do you understand? So what you're pleading to in that file under 7411 is controlled substance use of meth. Count 2 is punishable by 1 year and or $1,000. And then there'd be forfeiture of all contraband, correct?
Just to clarify, it's $2,000.
$2,000, all right, thank you. All right, and then what you're pleading to on the other file, which I'll note is the main file concern, is count 1, criminal sexual conduct 3rd degree by force or coercion. And that is a felony punishable by 15 years, mandatory AIDS, STD testing, and DNA is to be taken upon arrest. Was DNA taken? Did they swab you? Do they have your DNA on file from previous? No? All right, so I'm going to be signing that order, so you'll have to comply with that, understand? And you'll also have to comply with the AIDS, STD testing. As to the stalking, count 2, that is a misdemeanor, punishable by 1 year and $1,000 and up to 5 years probation, although we know that your agreement is for 36 months. So the sentence on this count 2 as well as the other file is all going to run together. Does that make sense to you? And then thereafter you'd be on parole. So there's no need for me to put you on probation. If you don't behave well on parole, you're just gonna be back in the Department of Corrections. You understand how that works? And it looks like you've signed the advice and rights form for both files. Did you understand what you signed?
Yes, sir.
If you had any questions about your rights, were you able to ask those of your attorney? And do you have any questions about your rights at this court? Yes, do you have questions or no? Okay, could you just move that, so you need to keep your voice up.
Okay.
Okay. I'm sure you've decided on this resolution and pleading to these 3 counts after talking with your attorney.
Yes.
You've made this decision of your own free will.
Yes.
And no one forced, threatened, or coerced you. No one promised you anything other than the plea agreement that we haven't made a record of, and that's why you're pleading. So there's been other promises. So that's correct.
That's correct.
And you're pleading after you spoke with your attorney and you've been satisfied with the representation of both files with your attorney?
Yes.
Sir, as to docket 261702 FH count 2, controlled substance use of a controlled substance known as methamphetamine, how do you plead?
Yes.
Turning to docket 256224 FH count 1, criminal sexual conduct 3rd degree by force or coercion, how do you plead?
Yes.
As to count 2, stalking domestic relationship, how do you plead?
Yes.
And sir, you understand that by pleading, you're also giving up your automatic right of appeal. If you had a bench trial or jury trial and you didn't like any part of it, something happened, the Court of Appeals must take a look at your unhappiness for whatever the reason is. But now by choosing to plead, it becomes their decision. So you will have to ask permission to appeal, and then they'll decide whether or not to take up your case. Do you understand that? And you understand you're also giving up your right by pleading to presumption of innocence, to holding the people to their burden of proof beyond a reasonable doubt, the ability to cross-examine witnesses and evidence, the ability to bring witnesses in your defense, etc. You understand all of that? And you understand that if everything goes well and I sentence you more than 36 months, then I would allow you to withdraw your plea and these files would go back to the pretrial stage. However, if you violate the law of bond conditions between now and sentencing, I don't have to honor that, and I don't have to allow you to withdraw your plea. Do you understand how that works? So returning to the 26 file, that's the use of meth. Did this occur on or about October 8th, 2025?
Yes,
In the city of East Lansing County, Bingham State of Michigan,
yes,
at a specific location known as Saginaw Highway in Grand River, you came in contact with law enforcement?
yes, ma'am.
Were you walking on a bicycle, in a vehicle, or something else?
Thank you.
Driver or passenger?
Sorry.
And why did you get pulled over?
They didn't give me any explanation as to why they pulled me over.
Counsel, any idea?
Was it for speeding? Was it
No.
traffic?
How did they end up pulling you out of the vehicle and finding the meth?
Because they ran my tickets on my plate, and they, just to check my insurance, and they said that, they ran my background right then and there, and they said that they had seen that I had been sworn out from my arrest for.
Okay, so that's the answer then, sir. They pulled you over because you had a bench warrant. So, and you would agree you had a bench warrant?
At the time, I didn't know that I had a bench warrant.
You didn't have to know, they knew. And they pulled you over, and they asked you to step out of the motor vehicle.
Yes, sir.
And then, where was the meth?
The meth was in my pocket, and I made them aware of it.
Okay, and they did, they searched you and did a safety search of the vehicle and you, is that correct?
Yeah.
And then you told them where the meth was, they found it, and it was in your pocket?
Yeah.
Which pocket?
Left pocket,
In the front of your pants, shirt, or other
pants.
pants? Okay, you placed it there?
Yeah.
And you understood that it was not lawful for you to use or possess methamphetamine, you had no license or special permission, correct?
All right, I didn't have my, ADHD medication or anything like that.
Okay, but you understand ADHD medicine is very different from methamphetamine, and you did not have a prescription for meth. Although you might have had a prescription for the ADHD medicine, do you understand those are two separate issues? Yes?
Yes.
Okay, very good. And you would agree with me that it was not lawful for you to possess that meth?
Right.
Great. And you had it because you were using it, is that correct?
I had it in substitute of, ADHD medication. I didn't have it.
You were self-medicating, but you used it?
Yeah.
Okay, very good. Turning over to the 25 file. Did these offenses occur on or about December 25th, 2024?
Yes,
In the township of Meridian, County of Bingham, State of Michigan?
yes,
You came in contact with April Garcia?
yes,
Well, you hesitated. Do you know her? Were you in a dating relationship with her?
feelings was mutual. In a case, me and her both Garcia, because she wasn't in the right state of mind to be in a relationship. So
Okay, but you knew who she was. You knew her, right? She wasn't just a stranger. Is that correct?
Well, she came to me at her store and was telling me about the situation that she was involved in with some, in regards to some guy named David and why he took her sexual toys from.
Okay. So did you know her before that?
No,
So this strange woman came up and talked to you about sexual toys from another man?
Yeah.
Okay, and then, did you end up having sex with her?
at some point in time, yes. We did end up having
What
sex.
point in time? Was it on, that Christmas day?
It was on the 17th, I believe,
17th of what?
December.
Okay, this happened on the 25th, it says here, so I don't know what happened on the 17th. So did you start dating on the 17th?
Yeah.
And did you get together again at Christmas?
Yeah,
Okay, so you knew her on that day. And did you and she end up having sexual intercourse?
yes,
And it was not wanted by her, is that correct?
that's what she believes, that's how she feels, I can't say no.
Well, did she say no?
She never said no.
Did you force her into a sexual relationship?
No.
Did she take her clothes off or did you?
She took her clothes off, I did.
Did you have any weapon with you?
No,
Did you offer her sex or some money or something else in trade?
for me to stay there in her house, in her apartment, I offered her $750 and $250 in food stamps.
Okay,
She took the offer,
and was the offer inclusive of sex?
and in my regards, my understanding, it wasn't including sex, but it's sex that came along. You know, there's a couple of times you see a woman walk out of her, walk out of a bedroom, or walk out of, place where, you have another male residing and you see him butt naked and get on the couch, or, you go to
Okay.
get in the shower, they go to get in the shower,
So let me ask you this, you saw her butt naked, and did you consider that an invitation to sex?
I didn't consider it, no, but it hadn't crossed my mind yet.
Okay, at what point did it cross your mind?
When we started engaging in conversation.
Okay, and were you dressed at that time?
No, I wasn't. I was getting ready to get into the shower myself.
So both of you were naked,
Yeah,
and then how did you come to touch her?
I told her I would. If she wasn't feeling good, I told her I'd take care of her.
Okay, somehow, according to this, your penis ends up in her vagina. That's not cleaning her up, that's having sex. Can you explain to me how we went from cleaning her up and helping her to putting your penis in her vagina?
I went from, it went from the shower to the bedroom in a matter of 15 minutes.
And did she say no? Did she say stop?
Yeah. Yes.
And did you stop?
Yeah.
At what point did you stop?
After I came,
Did she say no before you came? So let me understand this. You're having sex. Everything's cool. You come and she says, no, stop, get off of me. Okay, give me the order of events, please. Otherwise, we have to go to trial on this, because I am not finding that there is a belief by you that you're guilty of something here. But the facts speak to it as you're describing it, but maybe not if she agreed to it and then have remorse later. So would you like to tell me the series of events, and then maybe council can jump in and ask questions?
well, she went to work, came home from work, it was Christmas Day. She said that, she wasn't feeling good that day before going to work. I told her, I said, hey, we'll just call in. She said, well, I'm only calling in for like a half day, so I might as well go to work. I'm like, all right, well, you don't feel good, just call me, call somebody. I was like, we'll come pick you up or something. And, the next thing I know, she got home from work at about 2 o'clock and got in the shower, said she wasn't feeling good. Then explained to me and, implied to me in the situation of, that it was sexually related, is why she wasn't feeling good. So I asked her if she, was pregnant, that you think could be a possibility of pregnant. And there was no explanation there, and the next thing I know, she was like, I'm getting in the shower. I was like, okay. I was like, just let me know if you need anything. Like, I'll be in here. And next thing I know, she had said that she came out of the bathroom. I was getting in the bathroom, and I walked in, she was naked. I was like, are you okay? The door was wide open, so I walked in, didn't think nothing of it, So I asked her if she was okay. And she said, no, she's like, I'm not feeling okay. We'll just lay down in the bed, I'll make some dinner. Hopefully that'll, fix things with you. And, next thing I know, she ended up, she got in the bed, laid down, I got up and got in the shower, got out of the shower. And she was like, we started cuddling, and then next thing I know that, one thing led to another, we started having sex.
Okay, you're missing something here, sir. You took a shower. This is a different order than what you told me earlier, but you took a shower and then you went into her room. Were you naked when you approached her in the bed?
I was in my boxers at first, and then when they got in bed, I had to take them off. Because I realized that she was naked as well.
Did she want you to take off your boxers? Did she ask you to join her inside the bed sheets?
Yeah, she asked me to lay down with her, yeah.
Well, laying down and taking off your boxers are two different things. Did she ever tell you to put your boxers back on? Did she tell you to get out of her bed? Perhaps someone could enlighten me by asking some questions from a police report, which I haven't seen, or provide me with. a
Judge, I can
police
do
report.
that if I may.
Please do.
Mr. Puckett, you met Miss Garcia through her work in December 21st. She worked at the Poly area, is that correct? And at some point and you decided to enter into a relationship, is that correct?
Yeah.
And you moved into her apartment on Lake Lansing Road in Hazlet, is that correct?
Yeah.
In December of 24, is that correct?
Yeah, yeah.
And turn your attention to this Christmas Eve on December 24th. You said she was working that day, is that correct? And she came home that day, is that correct?
Yeah.
And did you talk her into persuade her to have sex with you? So she wanted to have sex, is that what your statement is? She never told you, I didn't want to do this, I don't want to have sex with you?
I mean, afterwards, like, probably about the 15th or so of January, when these statements were made to the police officer, when those statements were made, yeah, that's when all the no's started coming out. No, I didn't want to have sex with you, I didn't want to have a relationship with you, it wasn't on the 25th.
So, sir, let me stop you there. On the 25th, you are convinced that this was consensual sex. She gave you consent. She never said no. Is all of that correct?
Yeah.
Let me just jump to the stalking matter. Did you, between the dates of December 26, 2024 through and including January 3rd, 2025, continue to see her, harass her, follow her, call her, demean her, anything?
I had no way to stalk her or harass her, I had no vehicle.
Did you move out of her place?
Yeah,
As of when?
it was.
So we have sex,
January.
you and she have sex December 25th. Did she kick you out after that?
The 25th or the 26th, yeah, the cop showed up and kicked me out.
Okay, the 26th?
Yeah,
And did you continue then to contact her?
no,
All right, I'm not taking this plea unless
Would agree, Your
we have
Honor.
nothing here.
I agree. At this point in time, there's not been a factual basis.
I agree with that.
Okay, sir, we need to set this for trial. How much time do you need to prepare?
Your Honor, I believe it is already set for trial. Well, actually, yes, well, it has not been set for trial. We can get it set for trial right now.
I mean, we have tomorrow if you're all prepared.
Your Honor, I am not prepared. I have not sent out subpoenas on this case, as this case was not set for trial.
All right, how many days of trial do we need?
Your Honor, I would need about 2 or 3 days.
Okay, put it as one of our upcoming backups because the last, 3 Fridays, I have not had a trial. We could have tried this. So put it as a backup and we'll keep, this is an old case, so it's gonna end up being one of our first ones and it's probably only gonna be a week long, right?
Probably.
So let's get it heard.
We can set it for May 22nd, Your Honor.
Great, May 22nd, sold. And that will be on the primary case. Do you want to go through with the plea on the, I know you made a package deal. Would you like to proceed on this?
As it is a package deal, Your Honor, no, not at this time.
All right.
So the only question that I have, I'm not against trying on the 22nd, is I start another trial, 29th, and I would like that week to prepare for that trial, given the nature of.
What's that trial?
It's a homicide trial.
Well,
That's my fault.
how complicated is this trial?
Not complicated, but I don't want to spend time I need to prepare for that trial in court here. I'll do it if you want me to, Judge. I just don't want
Well,
Maybe we should
I
do that,
understand, but
right?
you know, you and the prosecutor and the attorney general are the biggest law firms we have, or among the top.
Right.
And so can you get a co-counsel or something? This case gotta be tried. This is a simple case. I mean, either she's gonna show up and say this happened. Was there a preliminary exam in this?
There was, Your Honor, and she did testify at that preliminary exam.
So we either, if she doesn't wanna show up, we've got the preliminary exam. It's the shortest trial in history. If she shows up and is not credible, the jury will find that. And, I mean, I don't know. Is this a real complicated case?
No, I'm not, and my concern is the other matter.
Yeah, I get it. Talk to your office, maybe somebody else can co-counsel, Mr. Goodrich or somebody, you guys work well together, I don't know. I'm gonna set it for the 22nd, if we can set it earlier, let's do that. All right. Thank you. If you wanna try the plea again, let me know before then. Hold on.
Who's next?
Who's next?
Randy Porter will be next, Your Honor.
Yes.
Shoot.
And like, he's not like, is he?
No.
That's not.
I am
I don't think so.
Is the victim here on this? There you go. All right. All right. This is docket 25495 FH, People of State of Michigan versus Randy Porter. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Burt Buxton on behalf of the people of the state of Michigan.
Jacob Perron on behalf of Randy Porter, who's standing to my right in person.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Have you had any medication, alcohol, marijuana, anything yesterday or today?
No, ma'am.
You're supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Thank you. And on behalf of the people, is the victim here?
Your Honor, the victim is not here at this time. His attorney is.
Do you wish to address the court?
No, Your Honor.
Is there restitution being sought?
There is, Your Honor. May I approach?
You may.
There is a notice of the victim, crime victim compensation award. Mr. Lang, the victim in this case, did go to the Victim Rights Compensation Fund and was awarded around $3,000. I have provided a copy of that notice to defense as well.
All right. Anything else on behalf of the people?
Your Honor, based off of that amount of restitution, I do believe that a period of probation would be appropriate in this matter. Given that being $3,000, I do believe he should be on probation for a period of time to make sure that that restitution amount is paid in full to the Victim Rights Compensation Fund. Thank you.
Counsel?
Yes. My client is come before the court and has acknowledged his responsibility in this issue. Obviously, he felt that his role in this was lesser than a felony charge, which is how we arrived where we're at. In regards to the restitution, he currently receives income-based SSI, as I understand it, as a sole income. So as far as putting him on probation, he'll be paying towards the restitution, but it doesn't, seem appropriate to put him on probation for restitution when it's going to be based upon Social Security income-based income. There was a lot of different moving parts that were happening during this process. It's kind of conceptually an imperfect type self-defense in a situation that didn't involve death or otherwise great bodily injury. And there was a significant misunderstanding that occurred that night. The victim in this case was at Mr. Porter's house for about 8 minutes inside with the door locked with Mr. Porter's girlfriend at the time, and he came home after being gone for 8 minutes and heard screaming and was locked out of the house. So he went in through a window and found a knife and thought he was defending his girlfriend from an intruder, which is, again, one of the reasons for the significant deviation on the plea. He has acknowledged that things got, a little more out of control than he would have anticipated, given the extreme heat of the passion, which is why we're before here today. He doesn't have a problem paying restitution, but as far as putting him on probation, he's remained out of trouble since this occurred and doesn't have anything since then to negate or to favor any type of a probationary sentence. And if we're going to give him probation on behalf of restitution, it seems like it's just a waste of resources.
Thank you. Sir, what would you like me to know?
It was a misunderstanding, a severe misunderstanding, and if I could do it all over again, it would totally be handled differently. It wouldn't have ended up like this.
Sir,
I'm too old for this.
counsel, are you disputing this amount?
No.
All right. You are too old for this, and you're older today because it's your birthday. Happy birthday, sir.
Thank you.
So here's what we're gonna do. You will pay the $3,923.80 to the victim rights compensation fund. You'll pay it through this court. We'll keep track of it. I'm waiving all other fines and costs except for the mandatory $198, which breaks down to $130 crime victims and a $68 state cost. So on top of that, you have to pay $198. How much can you pay per month?
150 a month, maybe somewhere in the area.
You're right. So it'll take you a while to pay, but I'm just gonna order $100 a month.
Okay.
Okay, and you can do that, coming here and paying it. You can do it probably by automatic, something downstairs, and they can do it, but I'm not gonna put you on probation. I think it's counterproductive. We've had you on bond conditions for 14 or 15 months. And so, they can get their money any number of ways, so I suggest you pay the $100 per month. Counsel?
I just want to make sure the no contact order lasts for the period of probation, whatever the court puts on.
Well, I'm not having him on probation, he's just gonna pay, so, the victim can get a personal protection order, but sir, if you need to stay away from the victim, you need to stay away from the victim.
Yes, no problem.
Okay, no violent behavior,
No
stay out of trouble, because I'm giving you a break here, because literally this should have been resolved a year ago, okay, and you have had nothing else. So I'm gonna trust that you're gonna pay the $100, not get into any more trouble and stay away from the victim and all other trouble.
Okay.
Happy birthday, you have 42 days to appeal and request appellate
Your
counsel.
Honor, I have a
Standing
question
appellate
on
rights.
this.
Yep.
The bond that I paid, someone else gave me money to pay it. What do I do about that?
So the bond that you paid, if somebody else pays it, it goes back to them. I'll order it back to them.
Okay, well, I mean, I paid it out of county jail, but they gave me the money.
I understand.
Okay.
So who's the person that gave you the money? Who's that?
Nicole.
Villarreal,
Okay, Ms. Villarreal,
yes.
you, I'm gonna order, and it's NICOLE,
Yes, ma'am.
VILLERAR,
REAL.
VILLERAREAL.
BILLARREAL.
Okay, so Ms. Villarreal, I'm gonna order that bond money go back to you, because if I don't do that, it's going to be applied to what he owes.
Thank you.
Okay?
Thank you
So
so
the
much.
check will be written out to you. I'll order that, and that means that both of you or all three of you can go down and deal with the clerk's office. But sir, I want you to keep good on your $100 a month.
You won't see me again.
Thank you,
And
Your
I
Honor.
will keep good on it. Give me
Thank
my
you.
word. Thank you.
Happy
Thank you,
birthday.
Your Honor.
So,
Did you say that? Oh, John, can I have the credited days?
I was about to say.
oh, sir, how many days jail did
Thank
you
you.
have? I'm sorry.
I believe it was 4 days.
Okay, 4 days of credit for 4 days. Thanks. Good luck to you.
Thank you.
Thank you, Your Honor.
That's tough.
Two more.
Mr. Freeman and Mr. Feigelson show back up, we will give you their Quinn or Hernandez.
Plea doesn't go through.
So nobody else is ready.
I don't believe so, Your Honor, not at this time. We're still waiting on defense attorneys to come in here.
Where are they?
Mr. Feigelson, I believe, is going over the plea paperwork with
This is docket 25-5164 H people of the state of Michigan versus Jason Thomas Quinn. Counsel, your appearances for the record.
Good afternoon, Your Honor, APA Burt Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Jason Quinn standing to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Thank you. Put your hand down. Sir, have you taken any medication, used any alcohol or marijuana yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had no time to speak with your attorney? All right. And are you employed?
Not full-time right now,
That's okay, what do you
no. HVAC, heating and cooling.
do? Okay, and do you still live on Berman?
Yes, ma'am.
And who lives with you?
I'm staying at my mother's house.
Okay. Sir, I understand there's going to be a plea today. Were you on probation, parole, or bond conditions before another judge on another file at the time of this? All right. And are you a US citizen?
Yes, ma'am.
On behalf of the people, what's the agreement?
Yes, Your Honor, and I want to apologize, I just realized that we had missed a count. But the defendant will be pleading to an added count 3 of attempted assault strangulation. Upon successful plea and sentencing, count 1, assault strangulation, count 2, A and B, and the habitual offender second will be dismissed. I had missed the A and B, so I apologize for that, Your Honor. On the original plea sheet. I had corrected it on my side, so I do not need an additional copy.
I just corrected it in ours, Your Honor.
All right, I'm correcting it on the original.
And there's also an agreement to no upfront jail at the time of sentencing. And I understand that Your Honor allows all victims to make statements, but it's just stated here on the plea sheet as well that all victims will be allowed to make statements.
I always allow that. I've never deviated, so that doesn't need to be for me, maybe for other judges, but if people are more comfortable with it being, that's fine. All right. With that being said, is it full, fair, accurate, and complete with that correction?
It is, Your Honor,
Sir,
But it's also the legal contest plea. That is marked on the plea sheet. I just forgot to say.
because of intoxication, Your Honor, lack of memory.
all right, sir, is that full, fair, accurate, and complete?
Everything that was said,
Yes.
I believe so, yes.
Okay. And you are pleading no contest because of lack of memory due to intoxication?
Yes, ma'am.
All right, and by stipulation, counsel has provided to me the Ingham County Sheriff's report, which I'll read at the appropriate time. And counsel, you're waiving reading count 1, 2, and the habitual second in its entirety.
Yes, Your Honor.
Thank you, as to count 3.
Yes, Your Honor. People of the state of Michigan versus Jason Thomas Quinn, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 3 attempted assault with intent to do great bodily harm less than murder or by strangulation. On or about September 1st, 2025, at 2980 Harmon Road, Dansville, Michigan, 48819, Ingham County, State of Michigan, the defendant did attempt to commit the following listed offense, and in the attempt did act toward the commission of the offense, but failed in the perpetration or was prevented in the execution thereof, contrary to MCL 750.92, assault with intent to do great bodily harm less than murder or by strangulation. The defendant did attempt to make an assault upon Grant Ryan Quinn with intent to do great bodily harm less than murder or by the crime of murder or by strangulation or suffocation, contrary to statute. This is a felony that's punishable up to a maximum, with it being an attempt, of 5 years and or $5,000. Court shall order law enforcement to collect DNA identification profile samples. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Court is to order law enforcement to collect a DNA identification profile sample before sentencing or disposition, if not taking the time for arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, ma'am.
So you understand attempt, assault, strangulation, is that what, I'm sorry, that's what he's pleading to?
Correct, Your Honor.
And that's punishable by 5 years and or what?
$5,000, Your Honor.
And or $5,000 plus restitution, if there is any to the victim. You understand that?
Yes, ma'am.
All right, thank you. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read?
Yes.
And if you had any questions, your attorney was able to answer those?
Yes, ma'am.
Do you have any questions about your rights at this court?
Not right now.
Sir, as to count 3, attempted assault, strangulation, how do you plead?
Guilty.
No contest.
There's no contest. Sorry.
So we're striking the guilty because it's no contest because of lack of memory, which the court is going to accept. And sir, you understand that by pleading, you are giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. Had you had a bench trial or jury trial and you were unhappy with anything, the Court of Appeals must take a look at your unhappiness, but now it's their choice if they allow you to appeal. And they will only allow you to appeal if they think your issues are important. Do you understand how that works?
Thanks, yes, ma'am.
You understand that you are also giving up your ability to cross-examine witnesses and evidence, to provide a defense, to hold people to their burden of beyond a reasonable doubt. If they could not prove that at any count, that would have to be dismissed. You could cross-examine any of their witnesses and evidence, and they could cross-examine yours. You understand all of those rights?
Yes, ma'am.
All right. And there is an agreement that's between all of you for no upfront jail. However, if you violate bond conditions or the law, you don't have to follow that between now and sentencing if you violate. Do you understand?
Yes.
However, if you don't violate and I violate your agreement, then I would allow you to withdraw the plea in this manner, would again go to the pretrial stage. Do you understand all of that?
Yes, ma'am.
Did this offense occur on or about September 1st, 2025?
Yes.
In the township of Bunker Hill, County of Bingham, State of Michigan?
Yes.
At a specific location
No, there is a police report for the no
Oh, I'm
contest.
sorry. Huh, I forgot we were going, I went right into,
But I don't think we went over the advice of rights.
I think I asked her if you
Oh, sorry.
signed the advice of rights and you understood that?
Yes, ma'am.
Okay.
Sorry about this.
So, he remembers the date and place, but now I'm going to proceed with the, Ingham County Sheriff's Office report, case number 2513303-633. The location, as indicated here, which is also on the felony information, is 2980 Parman Road in Dansville, Michigan. This is the township of Bunker Hill, County of Bingham, State of Michigan. And it appears that officers responded and made contact with Jason Quinn. And that was.
It should be the next paragraph. I apologize, Your Honor.
Huh?
It should be the next paragraph.
Yeah, I'm figuring out that. All right. They also made contact with him earlier at his mother's house at 2632 Edgar Road.
Just to clarify, that would be Carter Quinn.
Oh, that's Carter Quinn. Okay, where? Joseph,
It's Carter Quinn's statement, Your Honor. Because Jason Quinn is the defendant, Carter Quinn is the victim.
Oh, I'm sorry. Yes, okay. So, law enforcement made contact with Jason Quinn at the jail. However, Jason stated at that time he was at a NASCAR party at his neighbor's house with Grant, Carter, and a few other unnamed individuals. And officer during contact with Jason noticed that there was dried blood on his shirt and pants in several spots. and saw dried blood in his hands and fresh scratch marks on his arm, with peeled skin attached. He had dirt and mud on his pant leg. They made contact with Carter Quinn at 2632 Edgar Road at his mother's house and had a conversation with Carter. Carter stated he arrived at his grandmother's house where their father Jason lives. Carter said they arrived between 1200 and 1300 hours on August 31st, 2025. And Carter said he, Jason, and Grant went across the street to the neighbor's house to play pool in the garage. A few hours later, Carter said Grant was now drunk and upset. Carter
Was now what
stated
upset?
he was now drunk and upset. Carter stated he went to the bathroom and returned. Now Grant was saying he was upset at Carter for never being there for him. Carter said he was also upset with Jason for leaving for over 10 years. Carter said the three of them got into their truck and returned to Sonia's house. And Carter states Jason picks him up with two hands and chokes him, Grant. Carter said Grant began gushing blood out of his nose. Carter said Grant was being choked up against the garage door and his feet were off the ground. Carter stated Jason then picked Grant up over his shoulder and slammed Grant to the ground, at which point Grant went unconscious, hit his head on the ground. Carter said Jason then, while sitting on Grant, sucker punched him 3 times while he was on his back unconscious. Carter grabbed Jason by the neck and threw him off Grant and held him down and instructed him to stop. Would you like anything else, Fred?
I believe that should be sufficient, Your Honor.
Same as defense, Your Honor.
Our counsel where promises, threats, or inducements other than those are placed on the record.
No, Your Honor.
No, Your Honor.
This court complied with court rule.
You have, Your Honor.
You have your,
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency, and based on the report and the stipulation of counsel and statements of defendant, it does appear that he was intoxicated, and so plea of no contest is appropriate. I also find there are sufficient grounds in the police report, which I only read part of, but there's more detail. And based on all of that, there is sufficient grounds to accept defendant's no contest plea and have count 3 enter. Counts 1 and 2 are hereby dismissed along with the visual second offense notice in their entirety. If there are any outstanding warrants, those would also be recalled and dismissed. Your sentencing date?
June 22nd at 10:30.
it works, Your Honor.
Sir, today you need to go downstairs and make and keep an appointment with probation. They're going through a very detailed pre-sentence investigation report, which we need for sentencing. If you fail to keep that appointment, then I will have you bench warrant and you'll just sit until probation finds the time to come see you. So please don't miss the appointment. If something comes up, you're ill, or if something happens, please reschedule time. Stay in contact with your attorney, follow all bond conditions. Is there anything else I need to address? And there'll be no contact order.
Correct, Your Honor.
No contact order will remain in place.
That means,
Understand
Mr.
that?
Quinn, you're not able to have any contact with your son. And if you were to have contact and they find out about it, you risk violating the kill agreement.
I understand.
And just to clarify that no contact order would be in regards to both sons, even though we had dismissed count 2.
Do you understand that, sir?
I didn't hear it, I didn't catch it.
That would be in regards to both Grant and Carter, even though Carter's charges were.
The no
Oh, the no,
contact
yes,
orders for
yes,
both of your sons.
Yes, I understand,
Okay.
neither one.
Okay, and that means you can't send messages to them through third parties either. Do you understand that?
Yes, ma'am.
All right, thank you. That is all.
Judge, I would have asked, I know not now, but at the time of sentencing, because I know their father and son, if we could have maybe limited contact at that time. We could address it.
We'll talk about that, maybe with some therapy in
Yeah.
place for like family therapy,
Yeah.
so everybody's safe. If something's going on there, we'll get to the bottom of it, it's sentencing, all right? Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Ron.
Mr. Freeman told me he would be next, so let me go see where he is at.
Well, I mean, this is the.
It is. So what was? Alright, this is docket 25-4159 FH, people of the state of Michigan versus Corey Scott Hernandez. Counsel, your appearances for the record.
Good afternoon, Your Honor. Andrea McCray, appearing on behalf of the people.
Good afternoon, Your Honor. Stephen A. Freeman, Public Defender, appearing on behalf of and alongside Mr. Hernandez, who is at council table. Thank you.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. When we were here last, you wanted some information and some more time to go over the pre-sentence investigation report. Have you done that now?
Yes.
Are you ready for sentencing?
Yes.
Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And you had no time to talk with your attorney?
Yes.
And you've read the pre-sentence investigation report to your satisfaction?
Yes.
Thank you. On behalf of the people, any corrections, additions, deletions, aside from the date, which I'm going to correct now, it is now April 23rd. That needs to be on the basic information sheet, the cover page, instant offense, and I'll see if it's in the evaluation and plan. Just give me a moment.
Sure.
And what about the jail credit days?
293.
Is there an agreement as to those days?
Yes, Your Honor, there is. Thank you.
All right, I'm changing that in all the same places as well. I've changed the date under the evaluation plan. I'm looking at the recommendation narrative and changing the dates to 93 as well. And then the date on the instant offense, I think I've got everything covered. Is there anything else that needs correcting?
Yes, there are a number of changes.
Okay.
Okay, so first, when we look at current convictions, charge 2, that is the incorrect charge. He pled to child sexually abusive material possession.
On 2 or 3?
Yep.
As to the final charge, count 1, or?
It's count 2. So the final charge, it would have been charge 2, but it was originally count 4. That's wrong throughout.
Okay, so I'm just gonna strike where it says final charges. It should say what?
Child sexually abusive material - possession, aggravated possession.
And I said that was count 2, right?
Yes,
Okay, and then I'm striking the rest.
correct. I mean, it should say habitual third felony. The NCL is 750.145C 4-A1. The maximum penalty should be 20 instead of 30. It's wrong under the plea agreement. On the Department of Corrections recommendations.
Okay, on the plea agreement, which that's a huge paragraph, what am I changing there?
Where it says count 4, child sexually abusive, should say child sexually abusive material - aggravated possession. So you can cross out activity, aggravated, distribute, promote.
Okay.
Also should be added to plea agreement is that defendant agrees to forfeit all devices seized as part of the investigation to the arresting agency. Turning to the Department of Corrections recommendation, count 4 should be child sexually abusive material, aggravated possession.
I'm sorry, where are you now?
Department of Corrections recommendation, so it's usually the
Oh,
page.
yes. Okay.
Under evaluation and plan, Stephen McCray should be changed to Stephen Freeman. Count 4 should read child sexually abusive material, aggravated possession. Okay. Date should be 4/23/26, the last.
Got that.
And then it should be added that part of the agreement was the defendant agrees to forfeit all devices seized as part of the investigation to the arresting agency.
Okay.
Turning to, well, we can handle that when we handle guidelines. Let's see here. Turning to adult history under criminal justice system, going to number 2 of 3.
Yes.
Final charges. Computers using to commit a crime, it's a class D as in dog.
Change the name.
Thank you. Of course, then on the present offense, final charges, count 4 should be the child sexually abusive material, aggravated possession.
And then count 7 should be on there too, correct?
Yes, I see it. You see it? We're looking at the same thing.
Under 2 of 3?
Nope, no, count, this would be 3 of 3.
Oh, 3 of 3. Oh, I got it, okay.
Okay, and then. So when we turn to the BIR, the basic information report, at the bottom, criminal history, sex offense convictions should be be 5. Number of prior felony convictions should be 5.
Sorry, what did you just tell me is 5?
The sex offense convictions,
Oh, are we on the cover page again then?
so we are on the basic information report
Oh, basic information, yeah.
where it says criminal history down at the bottom, and then there's a big table.
Yeah.
You go to like 3rd or 4th row down, sex offense convictions, and then number of prior felony convictions. Both of those should be 5 instead of 4.
Okay.
Then turning to basic information report, current offense, obviously offense 203. Again, should read the child sexually abusive material, aggravated possession, and should have the PAC code of 750.145 C4-A1.
Sorry, can you read me the PAC code again?
Of course.
750.1.
C as in cat, 4-A1.
Okay.
Your Honor, the only other addition I have to the body of the PSI is that I want to move to include police report number CCU-0001487-25. It's the original incident report plus the supplemental number 1. And I want to do that because the PSI writer didn't include in its description of the incident, it just included what was recovered on his phone, but the plea was to him possessing and sharing the CSAM over kick. So we need to have both for guidelines.
Okay, so we're adding that. Do you have that for me to add?
Yes.
All right.
I think I know, but
Yeah. So that's something. Yeah. Well, not the summation, it's physically, moving to add this, so she would attach it to the back of the PSI. So that there is a preponderance of exactly what the offense was that he pled to.
understood. Thank you.
And that's all my changes to the body of the report.
Counsel, did you have any changes to the body?
No, Your Honor, and for purposes of the record and information to the court, I did receive an email from Ms. McCray earlier this month, wherein she indicated what she believed changes should be. I took a look, and I have to say I agree. So
Okay, great.
we're all set. Thank you.
Thank you. And that's the guidelines.
Thank you, Your Honor. Turning first to each child sexually abusive activity, aggravated distribution, PRV, and this I think goes for all 3 for these PRVs. PRV 1 should be 50-50.
Changes been made
PRV 2 should be 10-10.
for all of them.
Yes. And so the total PRV points for all 3 would be 82. For child sexually abusive activity, well, it's F for all of them because he maxes out. So F as in father for the PRV level for all 3.
And we're changing that then on the basic information sheet and all the counts, so it'll now read on the PRVs 82 and F.
Thank you, Your Honor. There are no changes to any of the OB variables. Turning to the first count of child sexually abusive activity, the guideline minimum range should be 58 to 171.
Sorry, it is 58.
58 to 171.
Thank you.
Looking at count 2, the child sexually abusive material aggravated possession, the guideline minimum range should be 99 to 240. And also the crime class should be B as in boy. Which, let me make sure that's changed.
So it's C for previous one, B for this one.
Correct, Your Honor.
Okay.
And it should be also changed under adult convictions, under final charges. They had put class C and it should be class B as in boy.
I changed that on count as. So the child sexual abuse activity aggravated distribution, is that class C? or
Yes, that is class C,
And then we're going to class B in the next one.
right, the aggravated material possession.
Yeah, and that's 99 to 240, and then what about the next one?
The next one is 38 to 114.
And that's class D?
That is class D, Your Honor, correct.
Okay. All right, so I'm gonna change the range of the basic information sheet for all.
Thank you, Your Honor.
Changes have been made.
Thank you, Your Honor. That is all the corrections I have. And then obviously, I think, I'm sure Your Honor already did, but under the recommendation narrative, changing the guidelines to come forth with what we ended up doing on the final.
Oh, yeah, and let me look at the bottom. Okay, I believe I've got it all correct. That was a lot. Okay. On behalf of the people, what would you like me to know?
Your Honor, thank you. This is a very disturbing young man. That's why the agreement is so high. He seems to have some form of an addiction to where he can't help himself when it comes to child pornography. You know, it was more than just possessing it, right? Because he was sharing it with other individuals on Kik, which of course creates supply and demand, which creates more of these issues and more a chance that children are going to be taped being raped for the pleasure of people like Mr. Hernandez. Beyond that, Your Honor, he had on his phone a notes section which directly talked about specific tips to help avoid law enforcement detection. Obviously, those tips didn't work because here he is. However, it's deeply disturbing that he was on HIDA for this same offense. Got that, not the HIDA, one of the HIDA cases was kept, but the other was not. He was revoked because of the new case, which was against CSAM. So he has this repeated history of looking at the child pornography. I'm not sure what the problem is. I hope he can get the help he needs in prison for whatever issues he has going on. But beyond that, Your Honor, this is a disturbing individual. So I ask that you follow the sentence agreement. Thank you.
Thank you. Counsel, if you and your client could come up to the podium and
Yes,
tell me
ma'am.
what you would like me to know.
Thank you.
You may proceed when you're ready.
Thank you very much, Your Honor. May I begin by indicating for the record that the comments offered by counsel with respect to the PSI and the additions, deletions, and changes and so forth, I did not have any objections to any of that.
Thank you.
I believe the guidelines are now scored properly as well. Either you have the prior convictions or you don't. So continuing from there, my thoughts on this case are as follows. You know, we've heard this before. We don't get to choose our parents, and that's true. We don't get to choose what color our eyes are or how tall we're going to be or anything else. For a longest time in this country, there was just a strict prohibition. Laws were passed against interracial marriages. And finally, we got over that as a country. And the same was true of same-sex marriages. But eventually, the courts, I guess, finally came to grips with the fact that if someone is attracted to someone of the same sex, that is just, it's not a learned behavior. It is a part of nature. Now, I'm not attempting to excuse any of the behaviors of my client. I hope the court understands I'm not condoning. I understand that it has to continue to be the law that sexual pleasures of any kind with children is just absolutely against the law. I'm sorry to say, though, that I think that the penalties involved are grossly exaggerated. I'm comfortable in stating, given my client's previous convictions, and then obviously these, that it is something that is inherent within him, but nevertheless is deemed unlawful. I'm asking the court to follow the agreement of the parties and sentence him accordingly. All charges to run concurrently and a minimum of 144 for the, I believe it's counts 1 and 2. That would conclude my comments. Thank you.
Sir, what would you like me to know?
I mean, I agree that it should. I don't agree that, or no, I don't agree that the penalties aren't too harsh given the nature of these offenses. I'd like to refute any notion that I guess I'm beyond help. And given the 12 years in prison, I do plan on working on myself as I should have before, but simply didn't.
What stopped you before?
Immaturity, lack of priorities. I didn't see what I did before it, as being as severe as what it was, so I didn't really put too much effort into addressing what I needed to.
Do you understand how serious this is? Whenever you spend even one penny or show interest in child pornography,
Yes, it perpetuates.
perpetuates it. It doesn't just happen once or twice more, it happens thousands of times more
Yes,
to children who are helpless without a voice, and they're used for profit.
yes,
They're used as things, not people.
and
How would you like to have been placed in that position when you're a few years old? When you're a minor?
I wouldn't.
So by you looking at it, promoting it,
Yes,
someone just like you is in that position. By the grace of God, it didn't happen to you. But you're causing it to happen to an innocent child and ruining their life forever.
yes,
Sir, I do hope that you get some help in prison. This sentence is designed for you to get help, to rehabilitate, to return and keep everybody safe. I assure you that if this happens again when you get out,
yes, I understand.
you'll never get out again.
Right.
The charges that you have here, you had what, 10 counts?
Yes.
And I certainly, had we gone to trial and you were found guilty of all of these, I could have stacked them one after the other, after the other, after the other, and you would die in prison. So I want you to know how lucky you are that everybody's working toward your rehabilitation. I hope you work toward your rehabilitation, because the next time someone will look at this is all public, and prosecutors and police will have access to information that others don't have. They'll make sure the next judge you're in front of is aware of this escalation of behavior, if there is any, and you'll die in prison. I'm pretty certain of that. I don't have a crystal ball, but of that I'm very certain. Because I see a lot of this. Because I know how other judges feel. So it's not us putting you behind bars, it's you. So, sir, you need to really change your behavior, make amends, seek treatment. There is medication that can be given for certain urges. And perhaps you can explore that in prison, and maybe when you get out. I don't know enough about it. I'm not a psychiatrist, psychologist, or doctor, but I do know that there are advances made in some of this area, not in the whole area of sexual assault. But for this, you may find some medication that stops the urge to do this. I don't know. In the next 12 years while you'll be away, there'll be even more advances made. So avail yourself of therapy. Have a support group. See what medication there is, so you can live a safe life. If you don't, you know the options, and they're very limited. The plea agreement was that you serve 144 months fixed, and that for all 3 counts, they be concurrent. So I'm going to honor that. As to count 1, you are remanded to the Michigan Department of Corrections for a period of 144 months to 360 months with credit for 293 days. As to count 4, 144 months to 360 months with credit for the 293. As to count 7, 144 months to 240 months with credit for 293 days served. You will pay a $68 state cost on each count and $130 crime victims. And waiving fines, costs, attorney fees, finding that you're indigent for that. While you are incarcerated, you will have mental health treatment, seek medical attention and intervention if that is available in this regard. You will have to register under the Sex Offender Registration Act, and you'll become familiar with that and receive all treatment as provided by that. This is registration for each of these, not tethered to, is that correct?
Yes, Your Honor.
Thank you. And in regard to employment, what is your line of work?
Previously it's just been factories,
Okay, so you have skill to get in the factory?
yeah,
Okay, so if you wish, you should attend trade school. That might help you when you get out. Do you have any history of trauma in your background?
I mean, yeah, abuse,
Okay, so you'll also participate in trauma counseling?
Yeah.
Okay. And cognitive behavioral? I believe this sentence is proportional to the crime, and it does speak to punishment of defendant, rehabilitation. It allows for rehabilitation if he wants to avail himself of it, deterrence of others, and protection of society. So you have 42 days to appeal and to request appellate counsel. Please give him his appellate right. Right. Sir, take this very seriously. Work on yourself every single day. Ask for help when you need it.
Yeah.
Good luck to you.
maybe.